a petition for confirmation of a non-agreed child support review order with 2 children.
The state is showing what has been marked as State's Exhibit A, the financial activity report, in this case consisting of 6 pages. The state requests that the court admit Exhibit A into evidence.
Are there any objections with this document being admitted into evidence? Mr. Peralta?
I object, Your Honor. I have never been sent this as a rules of discovery. I've never been sent this information.
Ms. Hill, did you provide a copy to all the parties?
I can provide a copy.
Okay, let's go ahead and make sure that all exhibits are sent to the parties. And Ms. Peralta, did you have an objection with this document?
I've never received a document either, ma'am.
Ms. Hill, are there going to be other documents besides this? Any exhibits?
This is the only state's exhibit. The parties, I believe, may have exhibits.
Okay. Does anybody else have exhibits that they're going to present to the court that they also need to share with the other parties?
I submitted it as per rules of evidence, Your Honor, yesterday.
Okay, but did you provide it to the Attorney General's office?
Yes, Your Honor, both parties.
Okay, Ms. Peralta, you received all of the exhibits from Mr. Peralta?
No, I didn't, ma'am.
Okay,
Your Honor,
let's take about a 10-minute break so everyone can go ahead and pass on exhibits so that we don't waste any time if somebody's offering those exhibits.
Yes, Your Honor.
Okay, so Mr. Peralta, do you need Ms. Peralta's email?
Welcome back to the channel. Today, we're stepping into a high-stakes child support courtroom battle involving 2 parents, 2 kids, VA benefits, domestic violence allegations, and over a year of disputed payments. The state is asking the court to confirm a non-agreed child support review order, and both sides are fighting over what really counts as support: direct VA money, temporary orders, car payments, and disputed arrears. On top of that, you'll see accusations of false statements to the VA, competing stories about who's the real aggressor, and a crucial fight over whether mom's personal information should be kept confidential for safety. Watch closely as the judge digs into the math, the timeline, and the credibility of both parents. Who do you think the judge is going to side with when the money and the safety concerns collide?
If it's not the one I have on file.
Okay, if everyone can put in the chat your email that you would like to have these exhibits sent to you.
Judge, the state objects. We have a request for a non-disclosure on file.
Okay. So are you going to share the information with
Your Honor, that is my non-disclosure, and I have waived my right to submit this information and get that information as needed.
Ms. Peralta, do you have an issue with your email being submitted to receive documents from the other party?
No, my email is fine.
Okay. I guess the court will note the state's objection and will overrule. Everybody wants to receive the documents, provide your email. Mr. and Mrs. Peralta, you're still under oath. Ms. Hill?
Yes, the state requests that the court admit State's Exhibit A.
Does anybody have an objection with this document being admitted into evidence?
No objection, Your Honor.
Ms. Peralta?
No, Your Honor.
State's A admitted. Thank you.
The state calls Ms. Peralta.
Okay.
Ms. Peralta, please state your name for the record.
Nancy Peralta?
Were you present at the child support review proceeding on May 5th, 2025?
Yes, ma'am.
And that agreement provided that Mr. Peralta was to pay current child support in the amount of $262 a month beginning July 1st, 2025, with a deviation being stated because you are receiving an apportionment of Mr. Peralta's VA benefits. Is that correct?
Yes, yeah. Yes,
Are
ma'am.
are you still in agreement with those terms?
Yes, ma'am.
And are you still receiving an apportionment of Mr. Peralta's VA benefits?
As of now, yes. But it will stop November 20 as he provided a false statement to the VA where he has been paying child support payments. So in November, I won't be receiving that apportionment anymore for the children.
And how much are you currently receiving?
$840.
And is that 420 per child?
Yes, ma'am.
And when did you begin receiving that?
I began receiving that, I believe it was in February of 2023 when they granted it. When I filed this was on January 5th of 2023. During our divorce process, I filed for this apportionment because he was providing me with $300 a month due to temporary orders, and I filed this for financial hardship. I had to flee Arizona for he assaulted me, and I had to come here
Objection,
to
Your Honor.
Texas
That's
with
a
the
irrelevant case.
children.
Hold on one second. There was an objection. What's your objection, Mr. Peralta?
Objection, Your Honor. She's going out of irrelevancy.
What is the relevance?
She said that I was arrested for domestic violence. As of the moment, that's a separate case. It's already been addressed in a different court.
Ms. Peralta, what's the relevance of your statement?
The relevance is, ma'am, that I did file this apportionment on January the 5th of 2023 for financial hardship, and I've been receiving these benefits since then, which they didn't count. I don't believe they should count as child support payments because these benefits are for the children since they are his dependents on his VA claim.
Objection overruled. Ms. Hill?
Okay, let's pause and unpack what's happening here. Nancy is telling the court she's been getting $840 a month directly from the VA. That's $420 per child. And as she asked for this because she had to flee the relationship, claims past violence, and says Dad was only paying $300 a month under temporary orders. Her key argument: this VA apportionment is for the children as dependents, not a voluntary child support payment from Dad. So it shouldn't erase what he owes. Elijah, on the other hand, wants those same funds treated as child support credit. The judge just overruled his relevancy objection, which means she thinks Nancy's backstory about hardship and why she filed for VA apportionment does matter. Question for you: should benefits that go straight to the kids because of Dad veteran status count as child support? Or is that double dipping if he also gets credit for it?
Has the amount always been $840?
That I've been receiving from the apportionment VA? Yes, ma'am.
Yes. Did you receive a lump sum or a different amount before you began receiving the monthly payments?
No, ma'am. A lump sum? No, ma'am. It's always been the 840, which is 420 per kid.
Okay, and the temporary orders that were granted during the pendency of your divorce, did they require that Mr. Peralta pay $260 per month beginning December the 1st of 2021 for child support?
Yes, ma'am.
And was there an additional child support required in the amount of $625 for the car payment?
That was ruled on our temporary orders, yes, because I had possession of the vehicle. In the end, I was asking for the vehicle that I have now, which he rejected to give me back, which was under my name. and the Explorer that he was paying for during our temporary orders was his vehicle under his name.
Then on July 1st, 2023, in the final decree of divorce, was current child support set at the amount of $1,302 per month?
Yes, ma'am.
And other than the payments that you received from the VA, did you receive any direct payments from Mr. Peralta since 2021 that did not come through the child support disbursement unit?
No, ma'am.
What direct payments did you receive prior to December of 2021 from Mr. Peralta that were not through the state disbursement unit?
I received a couple of payments from him, which were the $300 that were uh from the temporary orders, because we were supposed to have those payments set by app close. For some reason, app close stopped working, and that's how he would transfer the money to my bank account because of app close not working. But those were not extra payments made by him.
And how much total did you receive through that method?
You know what? I don't have an exact amount.
Do
It
you
just
have,
happened. I submitted some exhibits of the app close amounts that he would send me, and that's all I have. I don't have no bank statements or anything like that.
how much did the app close? How much does the app close show that you were paid?
Some are 200, some are 100. The reason why was because app close only allowed to be sent 200 a day. So he would deposit the following day another $100, which added up through to the 300 that he would send.
And do you have a total dollar figure for those app close payments?
I don't, ma'am. But it happened through the course of our temporary orders, through the final order. So maybe like a year and a half of $300 payments.
Okay, and you stated that the $840 that you're currently receiving direct payments from the VA benefits will end in November of this year. Is that correct?
That's correct. Because he made a false statement to the VA that he was paying child support.
Do you have any concerns with your safety and well-being if your personal information is placed in the order that the court makes?
Yes, ma'am, I do.
And what are those concerns?
He's been violent with me in the past. On June the 2nd of 2025, we had an incident during our exchange where he slammed his door on me and was pushing me.
And what resulted from that exchange?
My older son left with him, and he took him to school the next morning. The reason the altercation started was because my son didn't want to get down from the vehicle, and I was trying to get my son, and that's when he pushed me and slammed the door against me from the vehicle.
And prior to that, when was the last time an incident of family violence occurred?
Um, that was in August 5th of 2021 in Arizona.
And what happened then?
Um, he drove off with me while I was inside the vehicle. So he was arrested for aggravated assault.
Are you requesting that the court make a finding of non-disclosure so that your personal information is not contained in the order.
Yes, ma'am.
Does Mr. Peralta know where you currently live?
Yes, he does.
And do you exchange the children at a neutral location?
At the police station, which I haven't been doing so because of my safety and because of the incident that happened on June the 2nd of 2025. I just kind of stood back, and I have my daughters help me do the exchanges with him.
And do you have any personal knowledge of Mr. Peralta's current earnings?
I know he does get his VA benefits, and I also know he has a business, which I provided you guys with the exhibits, which he's had it since October 11th of 2024. The name is High Rock ITBCS, which he has been withholding information for the past year.
Do you have information as to what type of business that is?
Yes, ma'am. It says character of business, professional, scientific, and technical services. And it's connected with his physical address, with his current physical address, his current wife.
The state passes this witness.
Mr. Peralta, do you have questions of Ms. Peralta?
I do, Your Honor.
Ask
Thank
your
you.
first question.
Miss Nancy, you stated that you are no longer present at exchanges because of your safety.
Yes, that's correct, Elijah.
Your Honor, may I introduce this exhibit? We will call this. We'll call this Exhibit B. You don't mind if I share the document now?
Yes, sir. Go ahead and share it.
Apologies, technology could be a little slow. Miss Nancy, have you seen this document before?
Mhm. Oh, yeah, it's a false statement that you provided because according to you, I was
Objection,
harassing
Your
you
Honor. She's not answering the question.
through my son's phone that you provided.
Ms. Peralta, Mr. Peralta is asking you questions, and you are required to answer them and just answer the questions being asked.
What is this? Let me see.
Continue, Mr. Peralta.
Miss Nancy, have you seen this document before?
No, I haven't.
Your Honor, I'd like it to be noted that this is an order of protection, provided that Miss Nancy is actually the defendant in this case, and she is the one who is actually the more violent one. It was granted by a judge in Arizona Superior Court. Here is the affidavit of service granted in Texas, and also another affidavit of service and injunction of harassment against Miss Nancy on behalf of my spouse as well.
Are you offering this as one complete document or separate documents?
One complete document, Your Honor.
So
This
we'll
is
name
the
it R1. Are there any objections for R1 to be admitted?
Objection, Your Honor.
Okay, Ms. Peralta, what is your objection?
I think this is irrelevant to the case. I mean, we are not here to submit any documentation of no order of protection. Like I said, I've been a victim of domestic violence by him. But this is just very irrelevant to the case. These
hold on.
papers
But
were never
your objection is relevancy. Okay,
these papers were never served to me, Your Honor.
Mr. Peralta, what is the relevance of these documents?
The relevancy is that she used this as an argument for an order of protection, which is wrong because it sounds like she's committing perjury in court at the moment. She stated to you openly that she is in danger, that she is afraid for her life, that she is against, she's going to be hurt. And
Okay, stop right there. Stop right there. Ms. Hill, does the state have any objections to R1 being admitted?
The state would object except to the extent that it is used to consider the non-disclosure, the request for non-disclosure that the state has on file. Any other considerations such as for access or possession or any other matters, the state objects to the document.
This is a big strategic moment. Nancy has been telling the court she's afraid of Elijah, describing past incidents of alleged domestic violence and asking for non-disclosure so her personal information doesn't appear in the order. Elijah answers by dropping Exhibit R1, an order of protection where Nancy is listed as a defendant, plus additional documents showing a harassment injunction tied to his spouse. He's basically saying, I'm not the only violent one here. In fact, she's the one the court had to restrain. The judge allows the exhibit in but limits its use. It can only be considered for the non-disclosure issue, not for custody, access, or possession. That's a really important legal nuance. The judge is controlling how far this evidence can go. So, what do you think? Does a protective order against Nancy change how you see her safety claims? Or do you think both parties are weaponizing past orders to gain leverage in the support dispute?
Well, I don't think we're going to hear anything about access and possession, are we?
And no, Judge,
no,
just
Your Honor.
making clear that it would be the state's would not object if it's taken into account only for the non-disclosure purposes.
Okay, so with regards to Ms. Peralta's objection, that will be overruled. The court will also note the state's concern regarding the relevance on the order of protection as to the non-disclosure request only. So R1 admitted. Thank you. Continue, Mr. Peralta.
All right. Miss Nancy, you stated that you have not received child support since the beginning of the separation. Now,
A false statement, Elijah. I never stated that I never received child support. I stated that you would give me $300 a month since our separation through temporary orders. So, I mean, I don't know where you're getting that. I didn't state that because I did state that you did provide me with $300 a month.
okay.
Any other questions, Mr. Peralta?
Yes, Your Honor. 1 second, please. You also stated that the vehicle was being paid for, correct?
Yeah, that was under your name.
And you also stated that that was also under temporary orders, correct?
I don't have temporary orders handy with me, so I can't answer to your question.
Your Honor, I would like it to be noted that even though it's considered temporary orders, it is still under the jurisdiction of the Office of Attorney General under Code State 154.
So noted, Mr. Peralta. Anything else?
Your Honor, I would like no more questions for Miss Nancy.
Okay, Ms. Hill,
The state calls Mr. Peralta.
go ahead.
Mr. Peralta, were you at the child support review proceeding on or about May 5th of 2025?
Yes, ma'am.
And did you agree with the terms of the order from that proceeding?
No, ma'am.
Did you agree with the amount of child support being set at $262 a month based on a deviation of Ms. Peralta receiving an apportionment of VA benefits?
No, ma'am.
Okay. Please tell the court why not.
I did not agree due to the mathematical findings and the financials findings of the Office of Attorney General. All evidence submitted was through the verification process. This process was not mathematically done correctly.
What are you claiming was not done correctly?
So the current mathematical equations that she submitted, that was submitted in document 1 by Office of Attorney General, it states that it does not include.
Can we stop? Hold on a second. Ms. Peralta is moving. We need to wait until she can be seated so we can make sure everybody is.
Sorry,
Okay, go ahead, Mr. Peralta.
That the current document does not include all variables of child support payment, including the vehicle and including the $300 per month through app close as ordered through the temporary order dated on April 2022.
Hey, Mr. Peralta, on State's Exhibit A, do you show that it provides for an amount due for the vehicle from the temporary orders?
The document A states that there's arrears, and arrears are not calculated correctly in accordance with that.
Objection, Your Honor.
What's your objection?
He's stating that the mathematical incorrect, but the rears that he has pending right now is irrelevant to the case right now, because this amount that he accumulated right now, it's from last year, which was October of 2024 when he stopped working. So anything before that had already, I mean, it shouldn't take effect to whatever he has on rears right now.
Ms. Hill?
The state would show that the financial activity report that's been marked as Exhibit A is correct and is self-authenticating.
Objection overruled. Continue, Ms. Hill.
What direct payments do you claim to have made to Ms. Peralta?
The direct payments can include the $300, then the direct payment to the vehicle that she was driving at the time, all in accordance with the temporary orders, as far as Texas State Code 154 as well, stating that that is in accordance with child support payment obligations.
Are you currently working?
No, ma'am.
You heard testimony from Ms. Peralta that you own a business. Is that correct?
Yes, ma'am.
And what is that business?
The business is a tech company and business, business solutions, such as helping employees learn their technology, helping the technology be installed, and things like that. However, this business has been inactive since 2024 due to funding issues.
Objection, Your Honor.
What is your objection?
I would like for him to provide any financial statements on that, to make sure it's been inactive for the whole past year.
Well, that's not a proper objection, so I'm going to overrule it. Ms. Hill?
Do you have, Ms. Peralta, do you have any knowledge as to the VA's denial, according to Ms. Peralta, of the benefits as of November of this year?
No, ma'am.
Objection, Your Honor. I submitted documentation where it states that he had reported to the VA that he was making child support payments. Therefore, that's the decision that the VA took to stop the payments according to Mr. Peralta's statement.
Ms. Peralta, that's not a legal objection. That will be overruled. Ms. Hill?
Nothing further for this witness.
Ms. Peralta, do you have questions of Mr. Peralta?
Yes, I do, Your Honor.
Ask your first question, ma'am.
Elijah, why would you go to the VA and report that you've been paying child support when you haven't?
Because it is my legal obligation to report child support to the VA, as the VA is not intended to use apportionment as child support.
That's not what the VA benefits office told me. So if you are not going to provide child support to the kids through the VA, how are you going to submit those payments since you haven't been submitted them since October of 2024?
Payments are supposed to be submitted through the Office of Attorney General Child Support Division Office.
But you haven't been in the past year.
Was that a
Since
question?
October. No, yes, it's a question. Why haven't you been submitting child support payments since October of 2024?
Because I am here and I objected to that through the Office of Child Support so that they can correctly allocate the funds into my account as the VA pays for it directly to you through direct payment processes.
So when will you be depositing the whole amount that is owed to the children?
When it is duly and legally ordered.
Well, it's been duly and legally ordered since the past year and a half. The only reason why you were submitting payments for a whole year was because they were deducting it from your earnings from your previous job. But ever since that job stopped, you stopped and you haven't.
Correct. Because the process has changed and the way it's been deducted has changed.
So how can I trust you to do this the right way so your children can have their support monthly without you going in line to the VA stating that you are providing payments when you are not? Children feed,
Your
children
Honor,
dress.
objection, leading. She's leading me. She's trying to lead me to.
No, I'm not leading you. I'm just asking you a question.
But okay, you need to ask one question at a time and to give Mr. Peralta an opportunity to answer each question. So one question at a time. Go ahead and ask your next question.
When will you be depositing the money for the children for the set amount that is ordered by the court?
As soon as the order is corrected after this court case and the judge signs the order, and I will file and pay as ordered by the court.
Second question, Elijah. I would like you to provide the court with financial statements from your business. You just had a wedding, bought a new car, and you're fighting for
Objection,
rear.
Your Honor, relevancy.
What's the relevance, Ms. Peralta?
He has the money to pay, and he is refusing to pay for his children.
Objection, Your Honor, leading.
Ms. Peralta, ask your next question and then we'll move on.
Hold on, let me see. I don't have no more questions.
Ms. Hill?
This state rests and closes.
Okay, go ahead.
The state requests that the court modify the proposed child support review order to provide for an arrears amount as of April 30th, 2025 to be $15,159.74 as shown on State's Exhibit A.
I'm sorry,
be-
can you repeat that number again? I'm sorry.
Yes, $15,159.74 to be paid back at $125 a month beginning November 1st, 2025. And that the court consider modifying the current child support to be the guideline amount of $1,102 effective as of the date contained in the proposed order. I'm sorry, effective as of November 1st, 2025. In the event that the
I
court
have a quick question. So in the proposed order, it's 9,483, but you want me to modify it to 15,159?
Yes, Judge, at the time, the calculations did not take into account the obligations under the temporary orders, and the Exhibit A FINA has those obligations.
Ma'am, I have a question. So, he
on.
has to pay.
Hold on, Ms. Peralta, hold on a second.
Yes, ma'am.
So Ms. Hill, so when the divorce decree was rendered, is there any language that says it's final as far as any judgments pursuant to temporary orders in the divorce decree?
Let me locate the divorce decree.
Because if I'm understanding correctly, you want to tack on the temporary orders even after the final divorce decree and tack it on to the arrears after the divorce decree.
What had happened, Judge, is the obligations from the divorce decree beginning in July 1st of 2023 had been entered. The temporary obligations prior to the divorce decree had not been entered. Those are now reflected on State's Exhibit A.
I understand that, but when the divorce decree was finalized, they both had lawyers. When the
Yes.
divorce decree was finalized, anything under the temporary order, whether it be to capture a judgment for any unpaid child support pursuant to the temporary orders, do you know, was that taken care of by the language that says when we have the discharge of, I'm sorry, when we have the relief not granted?
I am looking, Judge. I do not believe the divorce order contained any reference to arrears from the temporary orders.
So is it the state's position that if there are temporary orders rendered, then you have a final divorce decree rendered? If they didn't capture a judgment, that judgment is still owed and paying, even though it wasn't pled for in the pleading that you're asking this court today to render a judgment.
Yes, Judge. It's the state's position that all of the obligations, since they were not reduced to judgment in the final decree of divorce, are due and owing. And to the extent that the state needs a trial amendment to request that relief, I request a trial amendment for that relief.
Well, I think that time has come and gone, but I'm going to deny that request. I mean, you can always appeal me, which is fine, but as of right now, that's going to be denied. So the next question I have is the monies that are given directly to mom due to dad's military participation, is the state giving any credit for that direct payments?
In the proposed child support review order, yes, Judge, the state is giving the credit of $840 a month as a deviation, making his current child support $262 per month.
But what about for the arrears that were rendered through the time of the divorce decree up until the point of the child support review order negotiation?
It does not show, Judge, that those payments are calculated in the financial activity report.
Okay, so if giving credit for those direct payments, how much would that be from the time of the divorce decree up until the negotiation conference rendering that judgment?
Judge, for 11 months of 2023, 12 of 2024, and 4 months of 2025 at $840 per month, that would be the sum of $23,520.
Let's break down what the judge just did. After hours of testimony about VA benefits, temporary orders, travel costs, safety concerns, and disputed math, the court makes a few key calls. First, the judge gives Elijah full credit for the VA benefits that were being paid directly for the children, wiping out the claimed child support arrears and bringing that balance down to zero. Second, she keeps the current support structure as proposed, including the modified ongoing child support amount going forward, along with the existing medical and dental support obligations. Third, despite both sides talking about past violence and safety, the judge denies non-disclosure for both parties, meaning their personal information will remain in the order, though she reminds them they can appeal within 3 days. Legally, this case is a sharp example of how courts handle VA apportionment, retroactive support, and competing narratives about who's really paying and who's really at risk. Emotionally, it's a reminder that behind the numbers are 2 kids caught in the crossfire.
So would that, in essence, if I was to give credit, that would wipe out the arrears?
Yes, Judge.
Okay, so with regards to the current support obligations, medical support obligations, dental support obligations, with the proposed order, what is the state recommending?
Due to Ms. Peralta's concern that the direct payments will end in November, the state requests that the court consider changing the child support due to $1,102, which is the guideline amount without the direct payment of the $840 a month, and that the current child support, medical support, and the current medical support and health and dental support remain the same.
Did the state receive any documentation that those payments are going to end on that date?
Only what has been provided by Ms. Peralta in this hearing.
Anything else?
And no, Judge.
Thank you. Mr. Peralta, is there anything else you would like to address the court at this time?
Yes, Your Honor. I would like to address the total financial amount as well that was given during that time when arrears occurred, thus giving me the opportunity to have extra credit on my account.
Anything else, sir?
Yes, if I can go ahead and show in my Exhibit A, if that would be allowed.
Well, right now we're at the point of just requesting what it is that you're asking the court to do, the exhibits and everything. Exhibit A from the state, R1 from you, all have been admitted as evidence. So now it's just giving the court, what is it that you're asking?
Well, my Exhibit A is the verification forms that Office of Attorney General requested, in which I sent in that shows all the documentation required to make changes to the account. As far as their code, Texas Administration Code 55, which they are responsible for.
Okay, anything else, sir?
And I would also like to also have it looked at to see if a reduction in child support could be done in the case of extraordinary costs to visit the children as of a distance of 463 miles away.
Objection, Your Honor.
Hold on, Ms. Peralta. And are you visiting your children regularly?
I try to as much as I can, Your Honor.
What are your expenses in travel?
Expenses could be about $80 per gas on average for both ways, and about $300 for housing. As of recently, I've been fortunate enough to have a friend who would allow my children and myself to stay with them during that visitation. But that's of this year. Since 2023, I've been having to pay $300 out of pocket for hotel costs or Airbnb costs every trip, and I have visitation twice a month on every other weekend, starting on the first weekend and the third weekend. And then I have extended breaks. Extended breaks are the financial grace for me because I can take them back home to Arizona and not have to deal with that extra cost.
Objection, Your Honor.
Doing the other travel to consider?
Can you repeat that, Your Honor?
Is there anything else that you want the court to consider? So far, I've heard your travel expenses, things of that nature. You want me to modify the support because of that?
Yes, that would be helpful. No, there's other costs such as clothing and things like that she doesn't share, but that is under my obligation. I'm not worried about that.
Okay. Anything else, Mr. Peralta, before I move on to Mrs. Peralta?
No, Your Honor, just that, and I believe you addressed the arrears in a way that's favorable for myself, so that is fine. Everything seems else accurate.
Well,
I would,
yet. I'm just asking questions. That's why I'm going to ask Ms. Peralta next.
yes, Your Honor. And I like to ask for maybe one more audit from the Office Attorney General to make sure records are accurate as much as possible. And the reason why I request this is because in 2023, in November, I requested a modification to figure this out as well, and it was not done at that time. And I believe that the state code states that they must do it in a reasonable amount of time, and I don't believe 2 years is a reasonable amount of time.
So you want them to review your case? Is that what I'm hearing?
That would be helpful, but if your order meets my needs and I can work with those numbers, then I am happy with that, Your Honor.
Thank you, sir. Ms. Peralta, it's your opportunity now to address the court on what it is that you're recommending for the court to consider.
I want to see if the court can, keep the rears since he hasn't been paying child support for the past year. On his expenses for the travel, I don't think that should be considered. He doesn't come and see the children unless it's long vacations, which is like summer break, and that he takes them to Arizona. He doesn't come every other, he's obligated, well, he has the right to come twice a month, which he doesn't. So it's only the long vacations that he comes and sees the children. He's not here regularly. If he sees the children 3 or 4 times a year, that's a lot. And I don't think the rear should be, for him not to be paid. I mean, it's okay for them to give him a credit and pay whatever the state recommended, which is $15,159.74. And that's it. I mean, why would he be, getting a deduction of child support when he doesn't come and see the children?
Objection, Your Honor. She's being
And
emotional and hostile.
he stays with his friend when he comes in here. So he doesn't have any cost and hotel cost or anything like that.
Okay, anything else, ma'am?
No, ma'am. And I do have proof where the children are staying at. If you guys need it, I do have the address where he stays and the location of my kids when they're there staying with him, with his friend.
Okay, that's not necessary. Thank you, ma'am. Ms. Hill, last word from the state.
I believe you're muted, Ms. Hill. Sorry. We didn't hear a word you said.
My apologies. The state requests that the court confirm the findings of non-disclosure that are contained in the proposed child support review order.
Okay. So earlier you heard me talk about appealing. You have every right to appeal my decision. That is in the form of what is called a de novo appeal to the district court. Once I sign the order, you have 3 days to appeal my decision. Okay, so whether you agree with my ruling or not, I get the order, I sign it. You will be notified that I signed the order. That's when your 3 days start to, the time frame begins. So based on the testimony and evidence before this court, I am going to amend the proposed attached child support review order. I am going to grant credit for the benefits that were provided for the children on Mr. Peralta's behalf through the VA. And that will now be a 0 judgment for any unpaid child support arrears. With regards to child support as it is proposed, I will continue that along with the medical support and dental support as proposed in the order. And the non-disclosure for both parties will be denied. Entry for this order will be this Friday at noon. Court costs will be assessed at 0. Unless there's anything else. Ms. Hill, did you need anything else from me?
No, Judge, thank you.
I think Mr. Peralta or Ms. Peralta may have questions. So if you can go ahead and answer any, and I'm going to move